I will call this meeting of the Senate Judiciary Committee to order. Would the esteemed secretary please take the roll?
Vice Chair Cannizzaro.
She is running a few minutes behind. Well, she's in another meeting right now, but if you will mark her present when she arrives, please.
Senator Orenshaw.
Here.
Senator Harris.
Here.
Senator Settlemeyer.
Here.
Senator Hansen.
Here.
Senator Pickard. Chair Scheibel.
Here, thank you so much. And welcome everybody to another in-person meeting of the Senate Judiciary Committee. I assume by now you are all caught up on the rules and regulations that allow something like 5 real people to be in the room, plus some legislators and staff. We will take the bills in numerical order. Well, after each bill presentation, there will be an opportunity for the members to ask questions. All of our members are here in person, but I understand some of the people answering questions will be via Zoom. We can all see them up on the Zoom screen, and last time I watched a committee meeting, it looks like BPS has, as always, exceeded expectations, and those of you watching at home will see the people answering the questions on your screen. After each presentation, there will be testimony in support, opposition, and neutral. We will do people who are in person first, and then people on the phone lines. And I also will have to step out around 1:30 to present a bill in an assembly committee, at which point one of my very capable colleagues will take over chairing this meeting for me. But until that happens, I will try to run this ship, and we will start by opening up the hearing on Assembly Bill 140.
Thank you. May I begin, Madam Chair?
Yes, please go ahead.
Hi, my name is Rochelle Wynn. I am the Assembly representative for Assembly District 10, which is in central Las Vegas. I'm proud to be here presenting my very first bill in the Senate ever. And also, I'm excited to be here in Senate Judiciary. Assembly Bill 140 comes from, I think, one of the best places. It is directly from a constituent who I also have here to answer questions and co-present. I have Miss Allison Brazier on the line on the Zoom call. She is a neighbor and came to me with a real issue that she was facing and that Nevadans were facing in our community when they were injured in car accidents by foreign nationals. And with that, I will actually turn this over to Mr. Justin Randall to kind of go through the details of the bill, what the intent is, and what this will do. And Chair, if we can go to him next, that would be great.
Yes, please go ahead whenever you're ready, Mr. Randall. It looks like you are speaking to us, but we can't hear you.
Sorry, I was muted there for a second. Let me step back. Good afternoon. My name is Justin Randall, and I am here to present on AB 140. I'm a practicing personal injury attorney here in Las Vegas. AB 140, essentially what it does is it's a service of process bill. So when an individual in Nevada is involved in a car accident and the case is unable to be resolved prior to filing a lawsuit, the lawsuit is drafted, filed, and then the next step is to serve the defendant, so the person who caused the harm. When we serve the defendant, if they are a resident of the United States, we typically go through a personal service, which means we have to physically hand them a copy of the lawsuit as well as the paperwork that was drafted. When they're a resident of the United States, typically we can find them within a reasonable period of time at a reasonable cost. If we're unable to find them and physically hand them that copy of the paperwork, then what happens, at least under Nevada law, is if they're a driver within the state borders, we're able to serve them through the DMV. There are other alternative forms of service as well, but in the personal injury context, the most common way would be to serve them through the DMV. And what that means is essentially the DMV would accept service on their behalf, which they consent to as a driver on the roads of our state. And that allows us to proceed with the lawsuit. Now, if the defendant is a foreign national or a resident of a foreign country, we don't have that option. Right now, under the current statutory law, we have the option of serving them through The Hague if they are a resident or citizen of a country that's signatory to The Hague, or if they're not a resident or of a country that's a signatory to the Hague, we don't have very many options whatsoever. This bill essentially attempts to close that loophole. And what that means is if they are a foreign driver that comes to Nevada, either as a visitor or a temporary person in the state, and they rent a car through a rental car agency, the rental car agency under this bill would be required to accept service on their behalf. Very similar to the DMV statute, and that's where this idea came from. Now, this bill is very common in other high tourism states. California has a virtually identical bill, Florida, Texas, and other states that have a lot of foreign visitors. The bill essentially would allow the DMV to accept the service on their behalf and then forward that service to the renter in the foreign country. Now, this is a major problem in high tourist areas, Washoe County, Tahoe, Las Vegas. We have a lot of high tourist areas in this state. And unfortunately, what happens is you'll have someone come here, visit Nevada, get into a car accident on our roads, provide limited information to the police, or even in the event that the police provide the wrong information or write down the wrong information. And then you have no real way of pursuing them to get the justice for the injured party within the state of Nevada. So essentially what this bill does is it protects Nevadans' ability to recover damages that are caused by a foreign driver on our roads. Essentially, it's closing a loophole, and it's a relatively straightforward bill that has been used in many other states that allows us to recover justice for Nevadans on our streets. And with that, I'm happy to accept any questions that you may have.
Thank you so much. Are there questions from members of the committee? I see a question from Senator Pickard. Go ahead.
Thank you, Madam Chair. First, let me just make sure I understand the process. I've done personal injury work, but never with a foreign national. It's my understanding that the rental car company is ultimately or typically ends up as the financier of last resort, in that they will be their insurance policy will be sought in the case that we can't reach the foreign national. My question then is, and so correct me if that assumption's wrong, but is it true that every foreign national who rents a car in Nevada must obtain the insurance through that rental car provider?
Thank you for your question, Senator Pickard. This is absolutely correct. So if you're a foreign driver and you come to the United States, you rent a car through, let's say, Hertz, Enterprise, whatever, you're required to purchase their insurance. They are typically either self-insured or through an insurance company, but in any event, they provide the insurance to the individual, and then the insurance that's provided would be what covers the loss or the damages for the individual that's been harmed by the foreign national.
All right, perfect. So
our position is that they're in the best position to contact that foreign national, because ultimately they're going to be responsible for the defense of that individual. They have the communication with the individual when they accept the rental, and they verify all of their contact information at that time.
that was good. You answered my follow-up question before I was even able to ask it. So perfect. That's all I have, Madam Chair. Thank you.
All right. Senator Harris.
Thank you, Chair Scheibel. I guess my question kind of follows up on Senator Pickard's. I'm wondering why we require service on the person at all. If we know the insurance company, the rental car company is who is ultimately going to be defending, right? Why not a separate claim where the rental car company then has to bring in the driver themselves if they'd like to seek some reimbursement for the costs of the injury?
Thank you, Senator Harris. Quite honestly, we would love that. That's not the way the system typically works in the United States. My understanding is there's only one state that actually provides that type of system, and that would be the state of Louisiana. So the 49 other states, including Nevada, under our rules of civil procedure, you sue the person that caused the harm, the tortfeasor, the actual defendant who hit you with their car or whatever the situation may be. And then ultimately the insurance will come in and defend and indemnify them for any loss or payments that are made. I think that's a great idea. I just don't think that our system has been set up in that way, but we'd be happy to go down that route if you wanted to, but I don't know that our friends in the insurance industry would be supportive of that.
And if you could just put your name on the record really quick.
Oh, and this is Justin Randall.
Right, if I could just add to what Mr. Randall said, this is Allison Brazier for the record. What we're trying to accomplish is similar to what is already available to drivers who are residents of the U.S. As far as alternative means of process of service. So right now, if you live in the U.S., we can serve by publication or through the DMV. And so we're trying to create a similar parallel track for international drivers. And so that's where the rental car agency being the acceptor of service for them would be similar to how the DMV would accept service for other drivers.
And this is Justin Randall. I'll give you some examples of this happening. So we, in the past year alone, and I operate a small law firm in Las Vegas, but I've run into this issue at least 5 times. Typically what will happen is you'll have an auto accident somewhere within Clark County, in our circumstance. The driver will hit someone else's vehicle. The police will come to the scene, and the police, in doing their report, will get portions of an address, maybe a city, maybe a state. You never know what you're going to get. But the information that is then communicated to the individual who was harmed on Nevada roads, so the Nevada citizen, is, and this is directly from an example I'm dealing with right now. We got a police report that says that the individual lived in Toulouse, Belgium, and at the bottom it also said France, and there was a street address that was found in a third country. So the information you're getting at the scene when it's a foreign driver is almost never accurate. And then the insurance companies who have all that information are not ever willing to provide that information to the plaintiff. So ultimately, the person being harmed here is the Nevada resident or the Nevada individual. So all we're trying to implement is a system that other high tourism states have found and used for years without any issue. And with that, we'll request any additional questions.
And thank you. I really appreciate that. I think if I'm understanding you correctly, not that I would encourage us to follow in Louisiana's footsteps all the time, but we could in fact set up our system that way if we so chose. It's just a little bit more work because that's not how we do things right now. Is that right?
This is Justin Randall, and I think that's fair, Senator Harris. We just don't have the system under our rules of civil procedure to operate in that manner, and we think it's a great idea. We would love to do that, but that is not the system we work within right now.
All right. I think we still have a question from Senator Settlemyre. Please go ahead.
Thank you, Chair. I was just kind of curious, is this kind of the industry standard amongst all the states? I would hope that we're trying to make it a little bit easier for individuals that are traveling around the United States or even from other countries. So I was just curious whether states, or is this somewhat of a standard now?
Thank you, Senator Settlemyre. I think this is becoming more of a standard. If you look at states like our state that have high levels of tourism, they are much more likely to have this standard. Obviously, lower tourism states, Iowa, something like that, may not have it. But if you're looking at a state, California, Florida, Texas, where you're having an influx of foreign visitors, it's a very common law to have and process to have.
And to follow up, if I could, Chair, in that relation, what does it look like around our surrounding states? Because it would make a lot of sense, too, to have similar laws to them, because at least in my area, up in Tahoe, people drive across the state line all the time, and down in your neck of the woods, the same thing occurs with the other states. Do you have any concept of what the states around us are?
This bill is virtually identical to the California law.
Okay. Thank you. Thank you, Chair.
I understand we also have a question from Senator Orenshaw.
Thank you very much, Chair Scheibel. And my question, either for the sponsor or for Mr. Randall, you know, we've got the traditional car rental companies, and then on a recent trip to Seattle, I saw this it's a service where people can rent a vehicle for a few hours. They do it all online. They don't actually deal with a person. I just wonder, and I don't know if we have this in Nevada, I haven't seen it, but if we do, would this apply if a foreign national is visiting Nevada and uses one of these services where they rent a car for a few hours of a day and then bring it back? Would this apply to them too if a Nevadan was injured?
Well, and thank you, Senator Orenshaw.
Your name,
if you look
please.
at the actual language, I'm sorry, this is Justin Randall. The language of the bill uses the term short-term lessee and short-term lessor, so it's not specific to a major company, Hertz, Enterprise, something like that. It specifically just deals with short-term lessors and short-term lessees as they're defined in NRS 482.05.
Thank you very much, Ms. Randall. Thank you, Chair.
Allison Brazier for the record. I just wanted to jump in because we do, as probably many of you know, there are bills, a bill that passed out of the Assembly and then I believe from the Senate to establish a framework for those peer-to-peer rental companies, which is I think what Senator Orenshaw was referring to. Currently, the way that those companies are defined under Nevada law, they are not considered to be short-term lessors, so they would not be included in this bill. However, in discussions surrounding these peer-to-peer company and the framework that they're going to operate under the state of Nevada, that's a concern that we've brought up, that they should also be included in this bill, since it would be a similar idea, but just in a different context of how the vehicle's being rented. So as the bill is currently drafted, no, it would not apply to those companies, but I think that in all practicality, that it should be considered.
Thank you. I appreciate that, Ms. Brazier. Thank you, Chair.
And Chair, if I can also answer, Rochelle Wynn for the record. The peer-to-peer and including them, it was something that we have discussed, and how we incorporate some of these new technologies and these new platforms that people are using to rent cars, rent pools, rent homes, rent RVs. I think there is not a whole lot that is untouched in the peer-to-peer, like app-based kind of platforms. It is something that we are continually having conversations on about how we can include those to make sure our Nevada drivers are protected in situations where they are injured in accidents by foreign nationals or foreign residents.
All right, it looks like we have a renewed question from Senator Pickard. Go ahead.
Thank you. And I just want to follow up on this point because if there's a bill running through the legislature right now that will require the peer-to-peer services to include the excise taxes, and that's done at the platform level. I would imagine that if we're going through that platform level for that, we could probably also require insurance policy procurement at that stage. Just food for thought. Thank you, Madam Chair.
Thank you. Rochelle Wynn for the record. Senator Pickard, it is definitely something that we've been talking about. I've been talking about this with the bill sponsor on that other peer-to-peer rental, like car type bill that is processing through the legislative process right now. So if we can incorporate that and have some consistency in the definition of what's included, it's definitely something that we're interested in doing.
All right, any further questions? I'm not seeing any, so we will move now to testimony in support of AB 140. Is there anybody in person to give support testimony on AB 140? I'll take that as a no, so we will go to testimony from the Ether BPS in support of AB 140, please.
Thank you, Chair Scheibel from the Ether. To testify in support on AB 140, please press *9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 140, please press *9 now to take your place in the queue. And Chair, at this time, there are no callers to offer support testimony.
All right, then we will move to testimony in opposition. Is there anybody present to give opposition testimony? Not seeing any, we will go to opposition testimony on the phones. Mr. Kyle, please.
Thank you, Chair Scheibel. To testify in opposition on Assembly Bill 140, please press star 9 now to take your place in the queue. Once again, to testify in opposition on AB 140, please press star 9 now to take your place in the queue. And Chair Scheibel, at this time, there are no callers to provide opposition testimony.
All right, in that case, we will go to testimony in the neutral position on AB 140. Anybody live and in person? Nope. Okay, anybody on the phones, please?
Thank you, Chair. To testify in neutral standing on AB 140, please press star 9 now to take your place in the queue. Once again, to testify in neutral standing on AB 140, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide neutral testimony.
All right, thank you so much. In that case, we will close the hearing on AB 140. Thank you very much, Assemblywoman Nguyen, for joining us, as well as our presenters. We will now open the hearing on AB 145. And for the record, Vice Chair Canizaro is here, and I will be handing over the gavel to her momentarily. Go ahead, Assemblywoman Cohen, whenever you're ready.
Good afternoon, Chair, Vice Chair Committee. I'm Leslie Cohen, representing Assembly District 29 in Henderson and a little bit of unincorporated Clark County. I'm honored to present Assembly Bill 145, the Uniform Registration of Canadian Money Judgments Act. The Uniform Registration of Canadian Money Judgments Act was drafted by the Uniform Law Commission. I'm not going to go into too much about that because I understand your committee is very well acquainted with that. But I will just remind you that ULC proposed legislation is nonpartisan in areas of state statutory law where uniformity is necessary and beneficial. And Nevada has a long history of adopting ULC law. Also, that, no uniform law is effective until it's adopted by a state legislature. So presenting with me, I don't think we have Commissioner Bacchus with us. I think she's in the next room over. But I do have Caitlin Wolf from the Uniform Law Commission Legislative Council. Can we just check if she's on the Zoom? I understand she registered.
Assemblywoman Cohen, this is Shay Bacchus.
okay.
I'm also here
Okay.
on.
All right.
Did you want me to go ahead,
Well,
Ms. Wolf?
I want to make sure we have Ms. Wolf.
Yes, hi,
Okay,
this is
great.
Ms. Wolf. I'm here, but Assemblywoman Cohen, if you'd like to go ahead and have Commissioner Bacchus co-present with you, that would be fine. I could be here for questions as well, but because Commissioner Bacchus is available, I think we should go ahead and let her co-present with you, if
Great.
that's okay.
Thank you.
Please go ahead.
Good afternoon, Vice Chair Canizaro, and I understand Chair Scheibel may have stepped away, and members of the Committee on Judiciary. For the record, I am Shay Bacchus. I'm here in my capacity as a commissioner for the Uniform Law Commission. Today, it is my pleasure to introduce Assembly Bill 145 with Assemblywoman Cohen, who is also a ULC commissioner. I want to first take a moment to thank Assemblywoman Cohen for sponsoring this Uniform Act. The Uniform Registration of Canadian Money Judgment Act is designed to work alongside with the Uniform Foreign Country Money Judgment Recognition Act, which Nevada adopted in 2007. This Recognition Act is now codified under Chapter 17 of the Nevada Revised Statutes, commencing at NRS 17.700 at sequence. With the enactment of the Uniform Registration of Canadian Money Judgment Act, a Canadian judgment once registered pursuant to the Act may be enforced in the same way as a judgment rendered in this state. There are several advantages to enacting the Registration Act. First, it streamlines the recognition and enforcement process of a Canadian money judgment. Under the current Uniform Foreign Country Money Judgments Recognition Act, a person who has received a foreign judgment has to file a lawsuit in order to have their foreign judgment recognized. This Registration Act offers an expedited administrative process to accomplish the same goal. This ultimately reduces the legal costs associated with enforcing the foreign judgment. Second, the process established in the Registration Act was designed to reduce judicial workload and help decongest court dockets because it does not require the court to hold a full judicial proceeding to recognize and enforce a Canadian money judgment. Third, this Registration Act establishes a registration procedure similar to the Canadian registration procedure regarding foreign judgments, including a judgment secured in the state of Nevada. This similar registration procedure will benefit those registering judgments from Canada in Nevada under this act, and those registering Nevadan judgments in Canada under the Canadian statutes. Most importantly, the enactment of this act will facilitate commerce between Nevada and Canada. Canada is one of the United States' most important trading partners. The Registration Act facilitates commerce between the two countries by offering a streamlined, less expensive procedure for the recognition and enforcement of money judgments, which are a result of commercial activity between the nations. According to the Business Council of Canada and Nevada, Canada is Nevada's third largest export market, and prior to COVID-19, 82,800 Nevada jobs depended on trade and investment with Canada. Thus, streamlining recognition and enforcement of Canadian money judgments in Nevada will continue to facilitate commerce between Canada and Nevada through the streamlined process. When this bill was introduced in the Assembly Judiciary Committee, it was convenient that it was the same week that Canada Day, that is celebrated in our legislature, had been celebrated in the 2019 session. At this time, I will turn the presentation of AB 145 over to Caitlin Wolf, who is the Legislative Counsel for the Uniform Law Commission, and she will walk you through the sections of the proposed bill.
Ms. Wolf, please go ahead.
Thank you so much, Commissioner. Thank you. Thank you very much. And thank you, Commissioner Backus, for turning it over to me. So it's a pleasure to be with the committee today. I appreciate your time and consideration of the bill. As Commissioner Backus said, I'm going to just walk you through the bill. It's a quick one. So first of all, sections 1, 2, 3, 4, and 5 are sort of general housekeeping matters, situating the act within the Nevada Revised Statutes, establishing the title of the act, and a couple of key definitions, including Canada, Canadian, and Canadian judgment. As we get into section 6 of the bill, that's where we go into more of the meat of the bill. So it explains that, as Commissioner Backus said, what we're talking about here is providing a registration procedure specifically for Canadian money judgments. So this section explains the scope and also explains that if a Canadian money judgment contains relief other than money, you can only use this act to seek recognition and registration of the money judgment piece. The same goes for subject matter that may fall outside the scope of the act. You may not use this act. Section 7 of the bill lays out the actual process one needs to use to seek recognition and registration of a Canadian money judgment. In essence, it explains that the creditor who's seeking recognition and registration needs to transmit particular documents to the clerk of court in Nevada. Subsection 3 explains that once the clerk of court receives the paperwork, that clerk, once they receive the paperwork, registration fee, it would file the registration, assign a docket number, and enter that Canadian judgment on the court's docket. Subsection 4 is also really key. It provides a sample form that could be used to facilitate this procedure. Section 8 of the bill then establishes that once a Canadian judgment is registered under the Act, it's enforceable in the same manner and to the same extent as a judgment that's rendered in the state. Certain types of enforcement activity are prohibited for a 30-day period after registration, just in order to provide notice to the party. And then for the 30-day period, of course, there can't be enforcement by disposition, seizure, garnishment of property, etc. Section 9 requires, again, that notice be served on the person against whom the judgment is registered. And it also states that the person against whom the judgment is registered can petition the court to vacate the registration as well. Section 10 explains that the person against whom the money judgment is registered can file a petition with the court to vacate the registration. They have 30 days to do so after being served with notice. And of course, there are only certain grounds upon which the person can seek a vacation. So a ground upon which recognition of a foreign country money judgment could be denied under your sort of existing law, the Foreign Country Money Judgments Recognition Act, or the person can argue that, the registration paperwork was filled out inappropriately, and thus the act can't be used to register that Canadian money judgment. Moving forward to Section 11, this section describes that a person that files a petition to vacate registration can also request the court to stay enforcement of the judgment pending the determination of that petition. Section 12 describes a little bit more about how this Uniform Act integrates with your current law, the Foreign Country Money Judgment Recognition Act. It specifically states that either a person can use the procedure specified under the Recognition Act. So as Commissioner Backus explained, that would be filing a full lawsuit, having a full judicial proceeding on the foreign country money judgment, or if it is a Canadian money judgment, they could use this simple administrative registration procedure. States cannot seek recognition using both acts at the same time. And then Section 13 and 14 establish our general uniformity language and also an effective date for the bill. So that is a very quick run through of the contents of the bill. I'm happy to answer questions as well. And thank you very much for your time.
And if I may, Chair, I'm sorry, before Leslie Cohen, Assembly District 29, before we get to questions, I believe we should also have Kirk Kaplan on the Zoom. I'm not sure. Your Zoom's different than our Zoom. Sorry. So if Mr. Kaplan's there, he is a Nevada attorney and CPA and a member of the Canada-Nevada Business Alliance, who maybe is not there. Okay, we'll just go on without him. He really likes the bill, though.
Okay. Well, thank you. We do have a couple of questions from committee members. We'll go with Senator Pickard first. Go ahead.
Thank you, Madam Vice Chair, and thank you all for presenting the bill. I will point out that all 4 of our legislative commissioners are present in this meeting. Myself and Senator Orenshaw, and of course, Assemblywoman Cohen and Ms. Backus. So it's good to see you all in this context. I've read through this, and my guess is, Assemblywoman Cohen, you're going to be able to answer this question. I'm wondering, because you and I are family lawyers, we deal with Canadian child support orders, which are judgments just as they are here in the United States. How does this interplay with our ability to enforce those child support orders? Do we need this order now? If we adopt this, does this become the standard? We have to follow this rule, or are we still able to enforce the Canadian child support order through the treaty?
Leslie Cohen, Assembly District 29, and I am going to punt to Ms. Wolf because, you know, Senator, I didn't even think about that. I don't think we've discussed that.
Happy to respond. This is Caitlin Wolf for the Uniform Law Commission. Senator Pickard, so this actually, I'm glad you asked the question. So this does not apply to domestic relations judgments. So we are specifically talking about money judgments as defined in your existing law, so your Uniform Foreign Country Money Judgment Recognition Act. There are certain exclusions. So again, domestic relations judgments do not apply, as well as certain other judgments for taxes, fines, criminal-like penalties. You cannot use this procedure for that. So I hope that helps answer your question.
It does, thank you. I just wanted to make sure that in my practice, in my day-to-day life, I know how to deal with these, and this maintains the exclusion. So I appreciate that. Thank you.
Senator Harris.
Thank you, Vice Chair. Forgive the basicness of this question ahead of time, but I'm wondering why only Canada?
Leslie Cohen.
Assemblywoman Cohen, I'm happy to jump in unless you'd like to.
No, you can go ahead. I think I would just point to Leslie Cohen, Assembly District 29, and point to, well, we do have that relationship with Canada, and that's that they have a similar legal structure as we do. There are not just the United States, but Nevada's major trading partner. But I will have Ms. Wolf go into more detail.
No, I mean, that's exactly it, Assemblywoman Cohen. So when the ULC was first considering this legislation, looking at the close legal ties, socioeconomic ties between the United States and Canada, and again, as Commissioner Backus already explained, there's a significant trade relationship between the United States overall and Canada, and then specifically between the state of Nevada and Canada, job creation. So when the commissioners were contemplating a harmonization project, they decided that because of those close ties and because of the significant business activity and litigation between the two nations, that it would be well advised to offer this streamlined procedure for Canadian money judgments specifically.
And if I may, just a quick follow-up. So I think what I'm hearing is it may make sense to do this with other countries. We just maybe haven't identified ones where we have the same relationship. But if for some reason our relationship with the UK blossoms so much, it would also make sense to put the same structure in place for their judgments. Is that right?
Go ahead, Ms. Wolf.
Thank you, Assemblywoman Cohen. Yes, and actually when the Uniform Law Commission first decided to study this area of law, they actually contemplated including some other, I believe, Caribbean nations and other countries, and ultimately decided to work with actually the Uniform Law Conference of Canada, which is similar to our United States Uniform Law Commission. That was actually the group that they paired up with on this to harmonize. And again, it may be worthwhile considering doing a streamlined registration procedure like this for other nations. But I think based on the data available at the time, as we mentioned earlier about the significant trade between the nations in close socioeconomic, legal ties, that it made the most sense to limit this to Canada at the time of the bill drafting. Thank you for the question.
Senator Orenshaw.
Thank you very much, Majority Leader, and thank you, Assemblywoman Cohen, for sponsoring Assembly Bill 145, and Commissioner Backus, thank you very much for presenting it and being so active with the Uniform Law Commissioners, and Ms. Wolf. And I appreciate the bill, especially because I've seen a lot of data about how many, Canadians come to Nevada and are snowbirds and part-time residents, and of course, many of our large businesses in Nevada are owned by Canadian companies. I believe Barrick Mining is one that comes to mind. I know that there are many, many others, but there's a lot of investment from Canada in Nevada and vice versa. I think there's a lot of investment from Nevadans over in Canada. So I think this will help facilitate business transactions. I noticed it's a pretty new act being promulgated, I think in 2019. Do you know, are other states considering this Uniform Act right now? Have any states passed it into law? I was just wondering, or would Nevada be the first?
Go ahead, Ms. Wolf. I had looked that up for my last presentation and forgot before this one.
So this is Caitlin Wolf for the Uniform Law Commission. Senator Orenshaw, to answer your question, because there has been an update since our last hearing. So one state, the state of Colorado, has enacted it so far. You're right, it is, Senator Orenshaw, a relatively new Uniform Act. So it was finalized by the ULC in the summer of 2019. So Colorado enacted it in 2020, and it is also pending in a couple of other jurisdictions this legislative session. So it's almost through in Nebraska. It's almost been enacted there. Minnesota, Maine, and Rhode Island are also considering it this legislative session, along with you all in Nevada.
Thank you, Ms. Wolf. Thank you, Assemblywoman Cohen. Commissioner Backus, thank you, Majority Leader.
And if I may, Vice Chair, Leslie Cohen, Assembly District 29, and I would just refer members to the Canada-Nevada Business Alliance website. Even though they're not specifically related to this act, it's really interesting to look at all of the business that is being done between our state and Canada. I mean, I know as Senator Orenshaw mentioned, mining is obviously one of those big business ties we have, but there are more. And as Commissioner Backus said, it's, right now we're at over 80,000 jobs. So it's something to kind of remind ourselves on the ground how we can get business done for the state.
I guess I have a question more out of curiosity, because you've made mention now of the Uniform Foreign Country Money Judgments Act. And so for Canadian judgments, are those currently, when sought to be enforced, done so under those particular provisions?
Leslie Cohen, Assembly District 29, there's just extra steps that have to be taken, is basically how it works. So we can, if you'd like, I'll have Ms. Wolf kind of go into the extra steps that are taken, but it's just, this will make it easier, less steps at court.
And Majority Leader, I haven't looked at that statute in a while. I think it's codified at Chapter 17 of the NRS, but I did get to work on that a few sessions ago. And I remember with the Uniform Foreign Money Judgments Act, there's a lot of extra steps that have gone in just to make sure that when someone has a judgment from a foreign country, that there's no concerns about the court system in that country, and no concern as to the validity of the judgment and the due process that happened in that country. And I believe what the Uniform Law Commissioners have done with this act, and I wasn't on the drafting committee, but because of our relationship with Canada, our confidence in their court system and their due process given to all parties being very similar to what our system has in this country, that a lot of the steps have been streamlined. Whereas with the Foreign Money Judgments Act, my recollection was that there were a lot more protections to make sure that the foreign country's judgment that we might be honoring had the same kind of due process rights that we have in our country for all parties involved.
No, and I appreciate that, Senator Orenshaw, and I guess Ms. Wolf, I don't know if you can talk, if those are the steps that we're streamlining here, or if there are additional steps that we're streamlining, and what the differences are.
Yes, Vice Chair Cannizzaro, happy to address that. So as Senator Orenshaw mentioned, yes. So you're under your current law, the Foreign Country Money Judgment Recognition Act, a money judgment that somebody wishes to have recognized and enforced in the state of Nevada, no matter which country it's from, Canada or otherwise, under current law, you have to follow that process, which means that you need to file a lawsuit and have a full-scale judicial proceeding about, just as what Senator Orenshaw mentioned, you need to ensure that there was due process, that it was in the foreign country. So there was due process, that it was a final, conclusive, and enforceable judgment. So there's no appeal going on in the foreign country. It must be final. Again, that there were no issues in terms of personal jurisdiction or subject matter jurisdiction. You need to have both in the foreign country. So in the state of Nevada, in order to recognize and enforce a foreign country money judgment right now, you have to have a lawsuit to make sure it's valid in all of those ways before that recognition and enforcement can happen in Nevada. So what we're talking about here in AB 145, because of this strong presumption of fairness of Canadian money judgments, because of our trust in their legal system, we are talking about offering those Canadian money judgments a streamlined procedure. No need to have a full-scale lawsuit or judicial proceeding to go through all of those steps. Instead, we're talking about essentially a simple, streamlined registration procedure, filing paperwork with the relevant clerk of court in Nevada, and skipping over the full-scale lawsuit about that foreign country money judgment. If it's a Canadian money judgment, you can file paperwork, and as long as you have that final complete judgment, there was due process, you've met all of those requirements, you can essentially file paperwork and have it registered, recognized, and enforced, rather than doing the full-scale lawsuit and going through all of those steps, as Senator Orenshaw mentioned. I don't know, Commissioner Bacchus, if you have anything else to add, but that's how I would best summarize the differences between the two uniform acts here.
Thank you, Majority Leader Canizero. Shay Bacchus for the record. I will echo what Ms. Wolf had said, but how I kind of distinguish it, just kind of boiling it down. One's the Recognition Act, which almost requires the original proceeding of filing to open a new case to recognize the foreign judgment. With respect to the Registration Act that's before this committee, is basically you're just taking that judgment and registering it with the court. No need to open up a original proceeding, let's say, to recognize it, where you have to have a full-blown evidentiary hearing to recognize the judgment, make sure everything's recognized. Instead, you're registering it and then serving it upon the judgment debtor, who would then have the opportunity to make those valid objections to due process. If the Canadian judgment was secured in an inappropriate way, they can then make their objection, and that's the purpose of the stay. So it's just registering the Canadian judgment in the state of Nevada, if this law were to pass, and allowing the opportunity for any objections to be made, instead of having an entire original proceeding and a judicial hearing to recognize the foreign judgment.
And so what I'm hearing is that the entire purpose of the lawsuit is just to ensure the due process and faith in the judicial system from wherever that judgment was obtained, and that piece is the only difference here that we're making.
And Majority Leader, if I may jump in, James Orenshaw, State Senate District 21. I'm looking now, I had to refresh my memory on recognition of foreign country money judgment acts, but at NRS 17.750, one of the things the court has to consider is the standards for recognition of a foreign country judgment. And among those standards enumerated in statute, was the judgment rendered under a judicial system that does or does not provide impartial tribunals or procedures compatible with the requirements for due process of law? Was there personal jurisdiction? Was there subject matter jurisdiction? These things here, because of the faith we have in our Canadian neighbors up to the north and in their court system, would be bypassed, which would be better for certainly business between both our countries, because of the faith we have in their legal system. Whereas with some other countries, there might not be that same feeling of comfort, and the court would have to look at those factors. And that's probably a short and quick answer, but.
Additional questions from members of the committee? Okay, I'm seeing none. Thank you, Assemblywoman. We will go ahead and move then to testimony on Assembly Bill number 145. If you are here in support in person, and I'm not seeing anybody make a mad dash, then we will move to those joining us virtually, and we will go to testimony and support. If you are waiting to give support testimony on Assembly Bill 145, now is the time to do so. So please follow the instructions from our Broadcast Production Services team, and I'm going to turn it over to them for testimony and support.
Thank you, Vice Chair Canizaro. To testify in support on AB 145, please press *9 now to take your place in the queue. Once again, to testify in support on AB 145, please press *9 now to take your place in the queue. And Vice Chair, at this time, there are no callers to give support testimony.
Okay, great. Then we will go ahead and close support testimony and open up opposition testimony. For anyone wishing to testify in opposition to Assembly Bill 145, seeing no one in person, so we will move to those joining us virtually. If you're here in opposition to Assembly Bill 145, now is your time to speak. Please pay attention, and we'll get your testimony.
Thank you, Vice Chair. To testify in opposition on Assembly Bill 145, please press *9 now to take your place in the queue. Excuse me, to testify in opposition on Assembly Bill 145, please press *9 now to take your place in the queue. And Vice Chair, at this time, there are no callers to provide opposition testimony.
All right, then we will close out opposition and open neutral testimony. Neutral testimony on Assembly Bill 145. We don't have anybody in person, so we will move to those joining us virtually. And Broadcast Production, if you could proceed with neutral testimony.
Thank you, Vice Chair. To testify in neutral standing on Assembly Bill 145, please press *9 now to take your place in the queue. Once again, to testify in neutral on AB 145, please press *9 now to take your place in the queue. And Vice Chair, at this time, there are no callers to give neutral testimony.
Fantastic, then. And we'll turn it over to you, Assemblywoman, if you have any closing comments on Assembly Bill 145.
Leslie Cohen, Assembly District 29, no comments. Just thank you very much for hearing the bill. Thank you to Commissioner Backus and Ms. Wolf for your work with this bill, and that's it. Thank you.
All right, thank you. We will close the hearing then on Assembly Bill 145 and move to the last item on our agenda for bill hearings, which is Assembly Bill 212. And we'll welcome Assemblywoman Anderson to the committee. Welcome, Assemblywoman. It's so great to have you.
Thank you so much, Majority Leader Canizaro, and hello, Senate Judiciary Committee. First of all, I just wanted to thank you for having this hearing so quickly after it passed. This is the first bill, actually, that I will be presenting on the Senate side this session, so I'm very excited to be here. My name is Nathan Anderson, and it is my honor and pleasure to represent Assembly District 30, which is in Sparks. I've had an opportunity to work with a group of court interpreters, which is very different than my world. As many as you know, I'm an educator. However, I have been involved with the Northern Nevada International Center for a few years now, and one of the large things that we do is something called the Language Bank. And over the last few years, we've been seeing more and more individuals from different communities needing the different services. And so with that, I've had an opportunity to meet with many of our court interpreters, and we've had a chance to really discuss things and some problems that have been happening. Literally, over the past 4 or 5 months, I've been working with this incredibly passionate and dedicated group of individuals who are bringing forward AB 212 today for you to consider. These individuals are so passionate because they truly believe that the phrase justice for all should be a reality and not just something that you say in a pledge. The court interpreters are, as stated in a 2016 U.S. Department of Justice Civil Rights Division report, they're a court-provided qualified interpreter, which is essential for a limited English proficiency, or LEP, criminal defendant, to effectively appear and participate in proceedings against them. Whether spoken or written, words lost or miscommunicated due to inadequate interpretations or translations may interfere with the court's ability to determine the facts and administer justice. For LEP individuals, accurate interpretation is the only way that they will be able to communicate their side of the story, preserve their evidence for the record, and challenge testimony of adverse witnesses. Interpretation requires a high level of fluency in 2 languages, and they also have to have a skill in conveying, sometimes simultaneously, what is being said. Interpreters who have not been properly trained or assessed may have trouble understanding or accurately conveying important information, including, as many of you know, very difficult legal terminology. Interpreters must also follow ethical standards to avoid providing evidence, expressing bias, or otherwise engaging in inappropriate side conversations with LEP persons. This was an area that I never even thought of, because I am not an attorney. As many of you know, I'm a teacher. And yet, when you speak with our interpreters, it is so important for them to have a voice in front of individuals who are making decisions for their jobs. As a matter of fact, one of the items that was brought up to me from one of these interpreters, again, referred to that 2016 Civil Rights Report, where they talked about a justice index, where the National Center for Access to Justice ranks states on a 100-point scale on a variety of issues. Nevada earned 16.8 points. That was in 2016. And although there have been many changes and ways to adjust this and make it better, we still have a long way to go, and we need to do so. By working with our Administrative Office of Courts, this is one way to be able to actually make some stronger proposals and help individuals who truly need this help. This bill is simply one step in trying to fix the problem. The proposals, and I'll walk you through them, are very quick. There's three specifically. The first one is expanding the number of individuals on the advisory committee by 2. One that is certified, a certified interpreter in Spanish, and one certified interpreter in a language other than Spanish. Because as we all know, Nevada is becoming a much more global community. The second is clarifying the reporting of the implementation of the Language Access Plan. The need for the Language Access Plan has been a plan from the Administrative Office of Courts, or AOC, and state courts for some time, and they have been working on it. However, when you take a look at the website, the 2013 plan is the last one that is present. From discussions with a member that currently is on that committee, or I'm sorry, just recently termed off that committee, there was a plan from 2018 or 2019. However, it is not easily accessible. It is not on the website. This is asking or legislating that it needs to be done so. The different items on this report should include the number of LEPs, individuals served, the language, the rate of utilization, as well as the type of resources provided. And after working with the newly hired, as in February, so just a few months ago, AOC Catherine Stocks, as well as John McCormick, we were able to get some language together regarding the statistical information as listed on section 1.4, which is the usage of certified and registered court interpreters and the demand for persons. If there's no need for it, then we don't need to spend as much time worrying about it. However, we do not have that data at this time, and we need to get that data to be able to make the strongest policy and laws possible. I know it's a very quick bill, but I also know that sometimes that's the worst thing to say, because then there'll be a whole bunch of questions, but I'm ready for that. So I just wanted to thank you for the opportunity in presenting this, and I'm more than happy to answer any questions regarding it. Thank you.
Great, thank you, Assemblywoman. Questions from members of the committee? We'll go Senator Pickard and then Senator Ornschall.
Thank you, Madam Vice Chair, and thank you, Assemblywoman Anderson. It's good to see you in this context. I mean, I deal with court interpreters on a fairly regular basis, and I just want to reemphasize your point that it takes more than just fluency. It takes a real skill to be able to simultaneously hear something, translate it, and be anywhere near accurate. And we are facing a real shortage of qualified interpreters in all sorts of languages. My question is, how does, I want you to go a little more in detail about how this dovetails, getting them on the commission, getting them not indoctrinated, but educated on the plan, and then helping to implement the plan. How does this ultimately result in more and better qualified interpreters?
Through Vice Chair Canizaro to Senator Pickard, thank you for the question. The main thing that's going to happen is, first of all, adding the 2 more individuals onto this plan, onto this advisory committee, we'll be able to bring up those very issues. What is the problem? Is the problem in that we don't have enough individuals that are taking the test? Which, again, there's a test that you have to take to be able to become certified. From the website and from information that I've been able to get from the other interpreters, there were 5 or 6 standard languages. However, there's an additional 22. But are they being offered enough times? Obviously, COVID-19 had a big impact on that since April of last year. However, do we have enough individuals that are taking those tests? So that's the first thing. And also having the courts make sure that those things are planned accurately. The second item as well is trying to, and this is where the hardest part is, it's taking the first step in a marathon. It's not just a mile, it's a marathon process. And so do we need to start talking about it more at lower levels? Even when people are in colleges and taking these classes, let's just say that they're taking a Russian language class. Do we ever talk about this as an item that could possibly be also a discussion? Hey, maybe you should think about becoming an interpreter. Maybe we need to do a heightened work on this as a career choice and other educational matters. But this is only one step in doing so. And so it's a way to try to get, first of all, the AOC and the committee that is doing the recommendations to the Supreme Court on these items to start getting that information together. Because we don't have the data to be able to say, here's the solution. And although I, as an educator and also as what you referred to before, when I would be in here on my other world, I understood how data would be utilized. Well, we don't even have enough data to be able to say what languages we're missing. We don't even have enough to know where exactly which courts are not getting it. And this is a way for us to start to do that. And that's, in particular, that is in the third section where the report would be utilized.
I appreciate that. And it was interesting. When my kids were in middle school and starting their foreign language, we had one of the teachers there who actually was a native Spanish speaker, encouraged their students, particularly those that were native Spanish speakers, to become interpreters. And so when I saw this bill, that was the first thing that came to mind was, can we use this as a platform to institute that interpretation conversation in the middle schools? So anyway, it's just I love the thought of this. So thank you, appreciate it.
Senator Arnshaw.
Thank you very much, Majority Leader and Assemblyman Anderson. It's really an honor to get to see you present this bill. And, there are just a few of us in the building who got to serve with your father. And there were many times when he was chairing the Assembly Judiciary Committee that I would hear Chairman Anderson say, I'm an educator, I'm not an attorney. But still, he was able to shape Nevada law in so many very positive ways. I know he'd be very proud of you bringing this bill. And very proud of many other things that I know you're working on this session. One question I have with this bill, and maybe the study will deal with it, but we've seen how well this new technology works with Zoom and Teams. And I've noticed in court that when sometimes we've had difficulty finding an interpreter, I once had a client in juvenile court who spoke kind of a Romany dialect, and we had great difficulty finding an interpreter who could help. Do you think that there might be more use in the future of Zoom or, having, if an interpreter's not here in Las Vegas or in Reno or in one of the court jurisdictions, letting them help electronically or try?
Through Vice Chair Canizaro.
You can go directly.
Oh, thank you. Thank you, Senator Renshaw. And I know how much Dad also appreciated serving with you. That is the hope. I mean, really it is at some point. I think at this point, however, we're not there yet. And so when this commission or when people are able to give that advice to the Chief Justice and to the other individuals, there's a way for us to be able to utilize that. I know that in many times, the language bank, which is something that I'm a little bit more familiar with based upon my work with other areas, we are able to utilize the technology, the Zoom in that fashion. But I think we have to have a little bit more discussion and trust amongst each other when it comes to the court cases and how that would work exactly. I know that there are some court cases or court areas that are very comfortable with it, and there are some that are not. And I think that there have been some things that we have had to learn as a culture and society, again, because of COVID-19. Washing your hands, for example, kind of an important thing again. Having that distance, again, an important thing. But I think this is another thing that we've learned is that sometimes technology can help us. And this is a prime example of it. If you are, and I'm making this up, it's important to know this, I do not have firsthand experience with this, but let's say that you are in a court case that is in Elko, and there's nobody that's able to speak, let's just say, Portuguese. How, do you call then? Do you call somebody from the Las Vegas area or from the Reno area that can do that? So we've got to figure out a way to be able to start utilizing that in a much more effective manner. And I think that this is the beginning to be able to do so in a much more consistent and effective manner. That is, again, in one of the goals.
Thank you, Assemblywoman. Thank you, Assemblywoman Anderson. Thank you, Majority Leader. And I apologize, I have to run over to Assembly Health and Human Services. Thank you.
Best of luck. Additional questions from members of the committee? Okay, seeing none, then we will move into testimony in support of Assembly Bill 212. No one here in person, so we will move to those joining us virtually. If you are here in support of Assembly Bill 212, now is the time for your testimony, so we'll turn this over to broadcast production and pay attention to the instructions.
Thank you, Vice Chair Canizaro. To testify in support on Assembly Bill 212, please press star 9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 212, please press star 9 now to take your place in the queue. Caller with the last 3 digits 024, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Senate Committee on Judiciary. For the record, my name is Manuel Mederos, and I'm the Language Access Specialist for the Northern Nevada International Center, which Assemblywoman Anderson mentioned. Before I provide my brief comment, I wanted to thank yet again our hero in this case, which is Assemblywoman Natha Anderson, right in front of you. Thank you, Assemblywoman, for all the efforts that you're doing and for your contributions to language access in our state. AB 212 is a very straightforward and, in my own personal opinion, adds even more diversity to the committee that advises the court administrator, in particular for adding a committee member that represents a language other than Spanish. In addition, AB 212 allows the committee to highlight their accomplishments annually and feature them in a public report. Such report would spotlight the important contributions the committee's commitment to the profession of interpretation, language access, and our limited English proficiency LEP individuals in our state. As Assemblywoman mentioned, Anderson mentioned, there are many gaps and many unknowns about the services that LEPs receive in our state, especially in our courts. This report that we're specifically talking about would assist in getting that important data so that we can all study it and come together to find solutions to address any issues and address any gaps. You know, the state of Nevada is very fortunate to have court interpreters which are trained professionals, which one of your committee members mentioned, that go through vigorous process to become fully certified in this state. They require to do many continuing education credits, many of them, and to keep their professionalism float, they have to go through a vigorous process. All these professionals love the art of interpreting. Better yet, they care and protect and love their profession so much. A court interpreter needs to possess not only a deep understanding of the languages in which they specialize, but also a high level of knowledge about the justice system and criminal procedures and legal ethics. It is essential that the court interpreters remain impartial and interpret what is being said precisely without allowing their own personal prejudices or values to seep in. So today I celebrate the contributions of all state interpreters of the state of Nevada because they do such an amazing job day in, day out. In closing, I would like to thank this body for hearing AB 212. I would like you to please support this very important AB 212 bill. Thank you so much for this opportunity to speak in front of you and for allowing me to spotlight the profession of interpretation in our state. We should all be proud of that. Thank you so much.
Thank you, caller. A brief reminder, we are currently on support testimony for AB 212. If you've recently joined us and would like to provide support testimony at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 206, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Thank you. Members of the committee, my name is Natalia Cardillo, Cardillo. I'm here representing the Nevada Interpreters and Translators Association, NITA, in support of AB 212. First, I would like to thank Assemblywoman Nessa Anderson for introducing this bill and for all her hard work to help improve language access to Nevada residents. Many of our members, including myself, are certified court interpreters, working with people with limited English proficiency so that they can receive their guaranteed right to due process, becoming their voice so that they can fully participate in what could be a life-changing process. As court interpreters, we undergo extensive training and rigorous testing in order to guarantee that we're accurately and completely interpreting for the public we serve. The certification and registration of interpreters, as well as the implementation of the Court Interpreters Program, falls under the purview of the Language Access Committee, which at this moment is not required to include any interpreters certified by the state of Nevada. The people that are most affected by its decisions and who has first-hand knowledge of the needs of the profession. AB 212 will add these important voices to the Language Access Committee. In addition, the publication of an annual report will provide the data upon which the legislature can make decisions in the future regarding the provision of interpretation services in Nevada courtrooms, thus ensuring that the use of valuable resources is effectively allocated to where it is most needed. I thank you for your attention, and I hope that you will vote in favor of AB 212. Thank you.
Thank you, caller. And as a reminder, if you've recently joined us this afternoon, we're currently on support testimony for Assembly Bill 212. If you'd like to provide support testimony at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 922, please press star 6 to unmute yourself. Once again, caller with the last 3 digits, 922, please press star 6 to unmute. One more time, caller with the last 3 digits, 922. Please press star 6 to unmute your microphone. And Vice Chair, that caller is currently unresponsive. So with that, there are no more callers to provide support testimony at this time.
Okay, great, thank you. Then we will close out support testimony and move on to opposition testimony. If you are here to give opposition testimony to Assembly Bill 212, now is the time. I don't see anyone in person, so we will move to those joining us virtually.
Thank you, Vice Chair. To testify in opposition on Assembly Bill 212, please press star 9 now to take your place in the queue. Once again, to testify in opposition on AB 212, please press star 9 now to take your place in the queue. And Vice Chair, at this time, there are no callers to give opposition testimony.
Thank you. Then we will close out opposition testimony and move to testimony in the neutral position on Assembly Bill 212.
Thank you, Vice Chair Canizaro. To testify in neutral standing on Assembly Bill 212, please press star 9 now to take your place in the queue. Once again, to provide neutral testimony on Assembly Bill 212, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 663, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Madam Vice Chair and members of the committee. My name is John McCormick, John McCormick. I'm the Assistant Court Administrator at the Nevada Supreme Court. And I just wanted to call in and say that we're neutral on the policy question of this bill, and we appreciate working with the sponsor on the Assembly side to alleviate our concerns via amendment. So thank you very much.
Thank you, caller. And with that, Vice Chair Canizaro, there are no more callers to provide neutral testimony at this time.
Great, thank you. Assemblywoman, any closing comments?
Thank you. First of all, I wanted to do a preemptive apology to the secretaries. I forgot to say my name after I answered the questions of the 2 senators, so please accept my apologies to the secretaries who have to now remember who that was. But in closing, and more importantly, I would just like to point out that Nevada has always had a rich history and dependence upon our interpreters. When you think about Sarah Winnemucca, who was an interpreter as well. And I just think this is another way for us to continue to honor that tradition and to make Nevada a much more inclusive area. So thank you very much for this presentation, and I look forward to talking with all of you again. Thank you.
Thank you, Assemblywoman. It is great to have you here in the Senate Judiciary Committee, and good to see you. We will go ahead then and close out our hearing on Assembly Bill 212. And members, that brings us to the last item on our agenda today, which is public comment. We will go to public comment. I don't see anybody in person coming up for public comment, so we will go to those joining us virtually for public comment, and we will turn it over to our broadcast production services to facilitate public comment. If you are here to give public comment, now is the time, so please pay attention to the instructions.
Thank you, Vice Chair Canizaro. We are currently on public comment. If you'd like to provide public comment this afternoon, please press star 9 now to take your place in the queue. Once again, to provide public comment, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 556, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Anne Marie Grant, ANNEMARIE GRANT, sister of Thomas Purdy, who was 38 years old when he had a mental health crisis at the Peppermill Casino. He was then hogtied by Reno police for over 40 minutes, dumped up at the jail, still hogtied, and then asphyxiated while still hogtied by the deputies. This week has been emotional with the huge support, publicity, and media attention that the murder of George Floyd received. I expected to see the guilty verdict in Derek Chauvin's trial. My immediate reaction to the news is that we need to see an appropriate sentence given and honored, or it's all been for nothing. This has been a common occurrence in the rare instances where a police officer is charged, which never happens in Nevada. To myself and other impacted families, this does give us hope that we still can get justice for our loved ones who were also killed by police. Being that my brother Thomas Purdy was killed in a similar manner by Washoe County and Reno police with his last words, also being, "I can't breathe, they're going to kill me." Our family wants my brother's homicide case reopened We are confident that an unbiased investigation dedicated to the facts will prove our stance. Washoe County District Attorney D.A. Chris Hicks is the only one who has the power to do this unless a higher authority steps in. None of the jail asphyxiation deaths, Justin Thompson, Nico Smith, or my brother Thomas Purdy, were ever reviewed by DA Chris Hicks. Please support bills that promote transparency and accountability from law enforcement. Watered down bills are just used to restore the public's trust in law enforcement, not to hold killer cops accountable.
Thank you, caller. Once again, we're currently on public comment. If you've recently joined us this afternoon and would like to provide public comment at this time, please press star 9 now to take your place in the queue. And Vice Chair, the phone lines are open and working. However, there are no more callers to provide public comment at this time.
Great, thank you. With that ends our business for the Senate Committee on Judiciary. So we will stand in adjournment and see you all back here tomorrow at 1 p.m.